Hi everyone, welcome to Lawyers Info Hub. This is your host Mercy. Nice meeting you. If you're seeing me for the first time, this is Lawyers Info Hub. This is a platform where we share legal tips. We'll talk about law. We talk about our experiences in the practice. We also bring people to share their experiences, aim at helping you to become better, learning, and become knowledgeful. We want to support, or we are supporting the legal education in Nigeria, in Africa. So today we're looking at default judgment. Default judgment. The law school, they will teach us about default judgment, or they always teach default judgment, summary judgment, and the like. But in practice, many people, once they start practicing, they begin to lose touch of all those things they taught them in the law school. So for young lawyers who is going to watch this video, this will help you, guide you to understand what you can do when you are being given a file, or when you are handling a matter. And for older lawyers, this is like a recap, and it's going to be of help to you too. So, what is default judgment? This is a judgment that is given in default of either pleadings or of appearance. So, sometimes how you see default judgment, you know, um, default judgment, for a defendant who refused to appear, or whether it's default in pleadings, the defendant refused to file its pleading after the statutory period had elapsed. When you file your originating processes, there's a time allotted to a defendant by the rules to enable him reply, or to enable it, depending on either an institution or a person, to respond to whatever allegations that have been buttressed or have been laid in those originating processes. So at the end of the time allotted to a defendant, and there's no response, there's no appearance, no process was filed. So in that instance, what the court can do is what the court can do in that instance is to, you know, buy the application of counsel, is to enter judgment against the defendant. So, for example, you have been given a file to handle, and you have filed your processes. There is evidence that's proof of service, and they are not coming to court. No appearance for them. No processes have been filed, and you can bring your motion, ask praying the court, you know, to enter judgment in default, either of pleadings or in default of appearance. Either way, in your affidavit in support of your motion, this is where you list out, or you you state out the facts surrounding your circumstances. You attach the affidavit of service to show, my lord, these people were duly served. And the court will look at it, okay, they were served, they are not willing to respond, they're not willing to, you know, come to court. Then let me enter judgment in default. And now, when the judgment is entered in default, when the judgment is entered in default, um, and suddenly the defendants appear and they are saying, my lord, set aside this judgment because of this reason, because of that reason, you know, what the court will normally do is the court will hear them, they'll bring the application to set aside the default judgment. The court will hear them and now consider, what are your reasons? What are your reasons? You were duly served, you didn't come, no appearance, no pleadings, and you're asking that I set aside the default judgment I entered. So the court will usually look at the application thoroughly, look at their reasons, and look at it to know whether you can set aside the application, the judgment, or not. So it's one of the reasons the court looks at is the court will look at the reason for their failure. What was the reason? Why didn't they appear? Was the process served at the wrong place? Is there evidence to show that the pictures, or for example, if it's a subsistence service that was served on is different from the address? if they show extenuating circumstances to say we were not served, these are the reasons the court will look at and say, okay, this application or this process was not given or dropped or served at the right place. Now, when there has been undue delay in making the application to set aside the judgment so as to prejudice the party in whose favor the judgment subsists, the court will look at it and say, well, was that undue delay? If I set aside this default judgment, it will only bring, it will not be in the advantage of the person who are already giving judgment for. Whether the applicant's case is manifestly unsupportable, if there are no cogent reasons why the court should set aside that default judgment, the court will not set aside the default judgment. The applicant's conduct throughout the proceedings has been sought as to make his application worthy of sympathetic consideration. If there are extenuating circumstances, maybe unto adjournment, the courts, enter that default judgment and they are saying, my lord, by the time we were served, the first sitting had happened. I had to get a lawyer. I had to show effort he made to get a lawyer. And before the lawyer could even make a search to know where the court and all that. If there are facts that will sway the mind of the court to have, that to have that sympathetic consideration. These are the things the court might look at and say, okay, I think I will have to consider this application. Now, the court in granting the application has discretion to impose such terms as it deems fit. Now, if the judgment is set aside, this necessarily implies a new trial. So the court might set aside this default judgment with conditions, and that they are willing to obey those conditions to enable the court to proceed. And the court is like, if you, okay, I'm going to set it aside, but this and this and these are things you're going to do. But when the application is refused, the affected party can appeal against the refusal of the application to set aside the judgment. Now, the appellate court will now look into the discretion of the court. The appellate court will look, whether the lower court acted on the right principle of law, whether the trial court decision results in injustice. And this is at the appellate court after the party must have appealed. Now, many times you will see cases last so long in court and you wonder what is happening. Now, sometimes it's important as a counsel for you to know what to do at every particular time. You have served your processes, this every day you're getting an adjournment, and you're sure that this person has been served, this company has been served the right way. So why not bring this application? Many people will keep applying it until the judge by this time will now say, counsel, what else can you do? In the circumstances, they are not appearing, no pleadings. What can you do? Make the necessary applications. This is when you see lawyers rising up from their slumber to now start asking, what can I do in this regard? So just bring your application, you pray the court to enter, default judgment. Now, and is it a default judgment, for that there was lack of appearance, or there was no pleadings? It's just a simple prayer of an order, an order of this honorable court entering final judgment against the defendants in default of either appearance or in default of pleading. So you will hinge on, is it that they have never come? So this is where you hinge on, or both. Is it in default of appearance and in default of pleading? Say, my lord, they were served on so date, the proof of service is here, you refer to it. You refer the fact that the rules of court provided for them to enter appearance within so days. Those days have elapsed. The court sat on this day, they were not there. Hearing notice was issued. The court sat on another day, they were not there. Hearing notice was issued. They didn't come. They have not filed their processes. So these are things you elucidate on, and the court will now grant the application. So do not sometimes encourage the delay in these matters. When you need to do the right thing, do the right thing and move on. Let them now come and say, my lord, set aside this default judgment. They will have to bring substantial reason why the court will set aside is the default judgment. Now you see that in setting aside the judgment of a default judgment, what the court is, the, for example, where there was no service, sometimes there could be issues of concocted service, they may not serve at the right place. So if they can prove that, see, there was invalid, I've said it before, is a complete nullity, then the court can look at it and say, well, they were not served. Now, where the default judgment is obtained as a result of mistake by one of the parties, if you are pleading mistake, then you have to bring the particulars of the mistake for the court to understand. Then if some people will plead fraud, You have to show what is the fraud, you know, you have to show what is the fraud and why you're relying on it and why you feel that is what made to come to court to tell you, or what cost the court or made the court judge to enter the default judgment. So whatever reason they're going to put forward in their application for the court to set aside the default judgment, it must be comprehensive, it must be substantial. So friends, default judgment, a lot of people have gotten default judgment, and it has over time they have gotten the executed it and all of that. So when you are in a matter and the other party is not willing, not forthcoming, there are things you can do. Sometimes you see people 5 years, 6 years, 3 years, both the lawyer, both the court, everybody just keep waiting and waiting. Maybe they came once and have refused to come. So should you wait for them for till eternity? At least one case off is off the docket of the court. So default judgment, these are ways you can get judgment. See, even at the level of pre-trial conference, many people have gotten default judgment. Even at the level, even a lot of people have gotten default judgment. Oh my Lord, I have served, and there's evidence. And see, before the court can even enter default, the court must satisfy itself that this will, because sometimes first adjournment, second adjournment, third adjournment, the court will keep hinting it and keep ordering hearing notice, and you keep bringing the proof of the hearing notice before the court can even agree when you bring this application. Because people, we have this mentality that when they serve them court processes, they feel what can they let them proceed, they don't do anything. But in other jurisdiction, once they get a court notice, they go to their lawyer to say, what does this mean, what is really involved, do I know? But here many people will just relax and say, well, it's not court. And at the end of the day, when judgment has been given, they start crying foul. That's not how it's supposed to be. So default judgment are those judgments you can get in default of appearance, in default of pleadings. When the other party is not ready, you get your judgment. For the court to look at it and say, okay, even what you're pleading, the court will look at it and give you judgment as it relates to your evidence, because so that there would have been documentary evidence, you know, documentary evidence to show that what you're claiming is right. But where you did not put documentary evidence, I wonder how the court will even grant judgment, enter judgment for you, because based on the documents you're provided, there's nothing to correlate your documents with your facts. But where there, for instance, they're talking about issue of land, there are some issues the court will want you to go and prove further. The court will say, okay, I want more documents, to expatiate whatever claims you are. But if there are simple issues of maybe debt, there's acknowledgement of debt, small issues that you have documentary evidence in proof, uncontestable, the court will look at it and say, I am of the view and I believe with the documents I have here that the defendant is owing this person so and so. So I'm just using this as an example. That other um, you know ways default judgment can come, not necessarily about only debt. So, but you have to prove it by documents in your originating process. But this is what the court will look at, say, I am satisfied by what you have put out that you deserve a judgment. That's what that is default. If they had come in their documents, will have just about both. But now they are not here. You have served them. They are where they have refused to come. I will have to do my job. So default judgment is very key. It comes in sometimes in your matter, and you must know when to apply for it and what to do and how to go about it. So today, I hope you've been able to learn something about default judgment, when what you need to prove to the court, even when the court wants to set it aside, what it has to look at. For the person who's asking the court to set it aside, what are those things you have to present to the court for the court to see and say, wow, I believe that I need to set this aside, or there is fraud, they were not served, there's a mistake on one of the parties and all of that. So when the court is satisfied in those, the court will look at it, okay, I think I need to set this aside and we start afresh. And the court might put terms to that setting aside to say, okay, I'm setting aside, but you have to be up and over this, or you have to pay this, or you have to do this, to ensure that the person will not go back to slumber having the court having set aside the default judgment. So, friends, it's been a wonderful time. I hope you learned something. This is Lawyers Info Hub. If you're yet to subscribe to that channel, please do hit the subscribe button. Share this video. Share to your friends, colleagues, mentees, mentors. Tell people about Lawyers Info Hub. Drop your comments if you have any. If you have questions, drop it. We'll we'll revert back to you, and we'll ensure that you're doing well. The best is yet to come, and you know that you can always be the best wherever you are Keep doing what you're doing. Be consistent. Be resilient. Don't allow anybody, demean you or demean your capacity. There is more inside of you, and there is more you can do. Do take care of yourself and to stay safe.